May it please your lordship. Lordship, I beg to mention item number 9, lordship. This matter today some difficulty, lordship. This matter may be passed off for the day, lordship.
You are
But I'm appearing-
other side.
Madam, I'm appearing to the respondent side, my lord. On last 2 occasions, they have taken adjournments. So a fixed date, my lord, and a last chance, my lord. That's my humble prayer. It's a POXO matter and there is a stay, my lord.
Last
Today-
occasion also take time.
My lord, yes. So last opportunity and a fixed date, my lord. Whenever it is convenient.
23/9, lordship, on 23rd.
May not be 23/9 because those 2 weeks I don't know. So let it be after vacation, but
Yes, as a last
as the last time.
Vacation, lordship.
on a fixed date, my lord.
Yes, I'll come in.
9.
You are MS?
M. Nirula, lordship.
Heart MS and neuropathic and constipation petition. And also heart. Mr. S. Nawaz did on it. Council appearing for the small number of promise and Mr. Ikeda Silana people appearing on behalf of status. MS Nirva, the council for the petitioner submitted. On what ground you want an adjournment?
Today some difficulty, lordship. Personal difficulty. All,
Personal difficulty of whom? Mr. Pijasakia.
yes, lord.
Ruler submitted that due to some personal inconvenience on the part of the case council, Mr. Pijasakia to be reported by adjournment. Mr. Nawaz raised objection and submitted that on the last 2 occasions also. The petitioner side paid for adjournment and cases to the approximate. He submitted that last chance may be given to the petitioner side for the hearing of this case. Considering the submission made by Mr. Nawaz, the matter be listed 16/10/2020 with a direction to both the parties proceed with the hearing without further adjournment. And that may be considered as a last list.
Interim order is there.
So you are enjoying the interim. It is cases
POXO and suicide, my lord.
Yes, lordship. We
POXO in suicide,
Suicide.
and that to now state.
Criminal
Proceeding is state.
state, my lord.
POXO proceeding is state. State, in fact. There may be some reason, I don't know. But generally, POXO is state. Anyway, 16. Oh,
obliged.
Made please, your lordship. Well, I beg to mention item number 21, madam. When the case there is not here, madam. I'm on interim, 29.
Not able.
21. CD not there.
Should be not able.
CD not received. Should remind
On 16/10.
16/10. 16. Based on 16/10, interim be extended till next.
Oblige, your lord.
May please, lordship, I beg to mention item number 25. I shall kindly adjourn the matter for the day and matter effect on PSD. Because we will engage senior and we will file a number today.
Yes, yes, what I have submitted.
For the day and matter fixed on Tuesday.
CD is available.
CD is available. You have to return it back. Are you on interim? No.
No, lordship.
You cannot fix it on Thursday.
Lordship will engage senior. We are going to file a
Whatever. What can we? This big case was fixed today. You took the adjournment. They are ready. CD is here. On whose fault?
In this case, Mr. Anja Dutta will appear.
No, whatever. The question is that whose fault it is the adjournment. You prayed for the adjournment. CD is available. Mr. Public Prosecutor is appearing. Then Tuesday may not be possible. Tuesday pariboda.
What does it?
Cannot be because these
Next-
last two
next week any date,
weeks most probably it will be motion weeks. So
Next
cannot
week in date. Lordship.
Huh?
Next week in date.
no date. If last week to dia Muslim. And 99 will be okay
19
for you. It's 19 of this month.
Oh.
Then we need to retain lot.
CDB. CD receipt for CDB retained till next set of weeks. And the request made by court and counsel for petition. Matter is adjourned. City be retained till next listing. Listing matter accordingly.
May I plead the Lordship? Lordship, I beg to mention one I criminal number 621/2019.
Make a mention before court number 16.
Much obliged.
May I please, Lord. May I please, Lordship, I will mention for listing, my lord. In this case, my lord, notice
No,
was,
whatever, list, it is criminal case or what?
my lord, W for criminal, my lord.
16. Oh, court number
Next.
16.
Madam.
Mention, make a mention before court number 16. We are not taking this regular bench.
May I please, Lordship? I beg to mention item 29 of today's daily list, Lordship. It may be fixed after vacation, Lordship, as the engaged counsel is out of sick leave.
29?
29, Lordship. That's my petition. I am for the petition.
The other side has not entered into appearance till then?
They have appeared, but last occasion might be they are absent.
Order column. It is in order column. Why?
Uh,
Why it is in order column?
Actually, we have filed one ad interim implication, Lordship.
Hmm.
Therefore, Lordship.
Otherwise, case ought to have been listed on admission or
Yes, Lord.
hearing. Or
Admission.
what? Huh?
Admission for.
But the other side is not here. Now what do you want? One adjournment?
Yes, Lordship. After
Who
the
is the
vacation,
engaged
Lordship,
counsel?
at any date, as per the convenience.
Who is the engaged counsel?
B. Hussain.
B. Hussain. So I is filed by the other side.
Yes, Lordship.
Have you informed the other side?
Lordship, we have tried to contact, but they are not available. Lordship.
They are not available. Three counsels are there.
Yes, Lordship, but we have tried a lot, but we cannot try.
To whom you wanted to, or you tried? You tried to contact with whom? There are three counsels.
Lordship, J. Hussain.
J. Hussain? No, J. Hussain is there.
Sorry, Lordship.
A. Hussain.
A. Hussain, Lord. Sorry.
And J. Ahmed is also there.
But we have no number, Lord. Yeah.
কি কৰিব আৰু, কি কৰিম? নাই নহয়, understand. তাতে বহুত complaint শুনিব লগা হয় ন। You wait for some time.
Lots-
Let you try to inform. We are trying
Highly
to
available.
make it up.
May I please, Lordship, in item number 26, I want to verify the LCR record. Please,
You
Lordship,
want to?
may I allow
Huh? You want to?
verify the LCR record, cross verify.
You want to peruse the LCR?
For both.
You have
One
received
to
the
two.
LCR. During court hours,
May I please, your Lordship? Lordship, I beg to mention item number 14, Lordship. The last
1/4.
1/4, Lordship. On the last occasion, Lordship, with the permission of this honorable court, I have gone through the LCR, Lordship. And I have gone through the statements also, Lordship. I am working on that, Lordship. Lordship, may kindly accommodate me for the day, Lordship. Any day, next week or before vacation. This is NDPS, Lordship. 22C is there, Lordship.
is the appropriate. $23.9. The request made by.
Highly
counsel for the petition. Matter is adjourned, list accordingly. দুইজনক দুইজনক
May it please, your Lordship?
Yes.
The application for regular bail. Second time we have approached this honorable court of Lordship, this is second time I have approached this honorable court. On first occasion, your Lordship was pleased to reject this bail application by the order dated 22/8/2025. Now here in this particular case,
we are moving only on one particular ground, that is the medical ground. We are not onto the merit of the case. And before we go into the details of this matter, would like to submit that the patient is currently languishing behind the jail since last 64 days. And as of now, charge sheet is also not yet filed. And his condition is deteriorating day by day. In fact, on the earlier occasion also, on 27/6/2025, a report was submitted regarding the urgency of an operation the patient requires for gallbladder stone. Now, the fact remains is that it was on 27/6/2025, the report was submitted. Now, after the rejection of the bail, this particular accused petitioner, being aggrieved with the fact that his particular condition is deteriorating and he is not being provided with the dietary supplement, which should be provided as per the jail manual also. Since he's not getting that particular food, what he has done is that he has approached the Honorable CGM, where the Honorable CGM, looking into the condition of the accused petitioner, had directed the jail authorities to approach the GMCS, since specialized treatment is required. Then what has happened is that when he has approached the GMCS, that is, my lord, page number 36, Annexure 8, here directly it is saying in that particular report, which is given by the GMCS on the basis of the jail authorities' action. Now here it is saying, my lord, that is Annexure 8, page number 36. That is this type copy of the advice slip. He is suffering from cholecystitis. Patient is a jail inmate. Patient needs elective cholecystectomy. Patient is explained about the disease and options provided regarding doing operation, OT, now or later. Patient has preferred to undergo surgery after bail. Now, the fact remains is that the new ground, that is why we are coming, is the fact that his health condition is very much deteriorating. And in fact, in our BNSS also, there is a provision that if 481, there is a provision that for non-bailable or cognizable offenses, if the particular petitioner happens to be a child, sick or infirm person, then this honorable court has the discretion to allow bail in that particular matter.
Earlier also.
Yes,
In
So,
IPC
yes, so here, considering his medical ground only, we are not onto the merit of the case. He is behind for 64 days. He's 65 years old. And in fact, this is a case where now already he himself had admitted also. He admitted that he is also involved in the offense. Now, the fact remains is that whether he has to go through this particular deterioration of his health inside the jail, or he has the privilege to go out in as per the strictest of conditions of this honorable court, so that he can go for updated medical treatment outside the state also, or in the state, but it has to be in a specialized way. And in fact, he has also stated that he is going to bear the cost from his own side. Now, the fact remains is that his family is having a lot of problem because he is inside the jail. The number one is that his wife is a psychiatric patient. Then he has got two sons. One of his is the elder son. He is having 75% of vision disability. Now, this person, the 75% disability son, he is completely dependent upon the accused petitioner. That is also one of the case. Now, he is physically handicapped. And at the same time, his mother, that is the wife of the accused petitioner, she is also having psychiatric problems since long time. We have annexed all the documents here. Now, that is why not going into the merit of the case, considering the length of detention as one of the ground, but main ground is that medical ground, so that this person, he is not having that proper, the entire, the treatment that is required. He is not getting it. And in fact, GMCS itself in its advice slip has stated that the operation is required. And as we go with the earlier report, kindly peruse to page number Annexure E, my lord. And sorry, my lord, it's Annexure Z, page number 34. There also, it can be clearly seen at that time itself, on 27/6/2025, in his custodial detention, it is saying, before the custodial detention, he was arrested on 9/7. So prior to his arrest, he was advised urgent operation for gallbladder, polyp plus stone, and consult with G surgeon, that is general surgeon. So at that time itself, he was given this advice. Now it is only slowly enhancing. And the stone, my lord, if we go into the medical jurisprudence, we can say that this particular procedure, why it is so urgently required also, this operation, the fact remains is that at that point, there was the increase of that particular condition, and it is slowly enhancing. The stone will only increase, and later on, it might result to a life-threatening condition, my lord.
And
Present-
and presently he's presently suffering from prostrate also. It is in para number 7, my lord, of our petition. That is a fresh grounds where we are seeking bail. He is having serious medical conditions that is already been submitted, and he's suffering from gallbladder polyp with stone and prostate enlargement. So he's having difficulty in urinating and that particular matter also. And now the limited facility that is provided inside the jail is not helping his cause at all. The fact remains is that he needs some treatment, and since the charge sheet is also not yet filed, and finally he is also having problem with his thyroid gland, and he's having a nodule, and it is also increasing, which may finally increase lead to cancer both in the thyroid as well as in the prostate region. So, yes, a lot of medical. He is having a medical history, but our concern is that he should have his operations. The operation which was advised by the medical doctor long time back prior to his arrest. Now it is from 27/6 it was there, and now it has come to this particular day now. So it is only increasing. He has even now refused. He is taking food inside the jail because the quality of the food is not up to the standard, or not up to that dietary supplement which is required for a chronic diabetes patient like him. He's a chronic diabetes patient only. So he's having a complete medical history, and he's a senior citizen, 65 years old. So charge sheet is still not yet filed, and considering the length of detention also, my lord, without the CD also, my lord can consider his case, my lord.
Otherwise, looking into the medical report what he has submitted, Lordship, prima facie seems that there are some medical problem is there. Otherwise, I'll leave it to Lordship whether Lordship will consider it on medical ground or not. Otherwise, I will call for the CD on short date. I'll leave it to Lordship.
Cancer treatment, my lord, requires specialized treatment. So slowly it is going to cancer also, this particular prostate, that enlargement that is happening now. So
What
that
is the stage of enlargement? Can you tell us now? You're saying that it is going to be a cancer. Maybe prostate cancer is there. I can understand. What is the cumulative enlargement now?
now it is stage 1.
There are many cases where the prostate enlargement is there. It may not be
Yes,
it may not be developed to cancer. Why saying that he is going to develop a cancer?
No, but slowly it may lead to. It may lead to. So that is our apprehension.
Where in the prostate also he was advised for urgent surgery in the prostate period also.
Yes, in
I
the
don't
order,
think so. There is no such order. No
in
such
the
medical document. He may suffer.
Yes,
I
yes,
can understand.
absolutely.
For prostate enlargement may be there.
yes.
And
And
saying that he is going to, it will lead to a cancer.
no, it is just
Not immediately,
yes,
it will not
absolutely.
lead to a cancer.
Absolutely, totally. My lord, my lord is very much aware of the fact.
Had Mr. W. or made it learned counsel for the petition. Application under section 12, eviction. Next, right, is submitted by Mr. Meeting, counsel for the petition. That the bail application for the present petition was earlier rejected by the order dated 22/8/25 in bail application number 2363 of April 2025 after period of the first time. But after rejection of the earlier bail application, the present application has been filed only on the medical ground of the present. It is submitted that presently before his arrest, also the doctor advised him to go for surgery for his gallbladder stone. But thereafter, when he got arrested, the matter was reported to the jail operating. And as he was not supplied with and he was not provided with a proper dietary supplement as well as the medicine, the matter was also reported before the learned CGM, and as per the order of the CGM, the authority had the petitioner before DMCH on DMCH, where he was advised for immediate surgery for his colon. he was diagnosed with polylithiasis, CHOLELITHIASIS, which needs immediate surgery. But is not getting such treatment inside the jail, and his entire family is also suffering from various illness, including his sons. So his family is also not in a position to provide any help to represent petition, go for surgery inside the jail premises. He further submitted that advanced treatment is required and immediate surgery is required for the present petition, for which one the in this petition is filed urgently on the medical ground. He further submitted that if the immediate surgery is not done, it may be a life-threatening for the patient, but for the petition. Apart from that, he is also a patient of diabetic. He is also a diabetic patient, and also with prostate enlargement, and also having a thyroid. Further, Mr. Mehdi submitted that the accused petitioner in custody since last 64 days, and thus I have got sufficient opportunity to interrogate him, keeping him in custody. And hence, further custodial interrogation may not be required. Just to be examination. However, Mr. Mehdi is still ready and willing to extend his cooperation in further investigation of this case. The petition is also annexed. The several medical documents also been annexed along with the petition, including the report advice slip given by the TMCH, wherein when he was taken by the jail authority. But next one, Mr. Das did an additional submitted in his report that his earlier bail application was rejected, considering the matter in his diary. Where he submitted that the patient may be in need of urgent medical treatment, as per which reveals from the annexures file along with the petition. However, he submitted that he submitted that there is no information regards to filing of the charge against within stipulated period. Next, but considering the submission made by learned persons and without going into the merit of the case, exclusively consider the immediate and urgent medical ground petition, which reveals from the annexed medical documents, and also considering the length of detention under petition, I find that under custodial petition may not be required for purpose of investigation. Considering on the certificate of CGM Kamrup M. CGM Kamrup M.
Yes, yes, ma'am.
You granted bail.
Obliged, obliged.
Lordship, this is a regular bail application, and its sections are of POXCO matters. Lordship, CP may be called for,
No, it's a POXO.
yes. Lordship, a humble request, kindly a date may be fixed.
May it please your lordship. But 3 and 8 may be taken up together, my lord, husband and wife, my lord. Actually, my lord, whatever, my lord, fault of the son, my lord. The father is behind the bars and my lord, the mother is on the run, my lord. Page 12 is the FIR. There is 3 and 8, my lord. 3 and 8, my lord. Page 12 is
And
the
H.
lordship. Page 12 is the FIR. They don't, not even a whisper against the father, my lord. Only the son has committed something, my lord. My lord, now my lord, father behind the bars for nothing, no fault. My lord, page 12 is the FIR. May I read, my lord?
No, it is a POXO.
POXO, my lord, again, where
Lordship, may kindly come to the FIR, Lordship. Lordship will find the FIR page 12, your Lord. Initially, he was granted your lordship interim bail, your lordship, by the London Special Judge Durhat, your lordship. But later on, he was sent to custody, your lordship. Initially arrested on 27, your lordship. He was granted 15 days interim protection, your lordship. Thereafter, he was sent to jail on your lordship 5
Why
2015,
interim protection was there?
lordship.
Why interim protection was there
For medical grounds, your lordship.
on me?
As because he is not the main, nothing was recovered from him, your lordship. And he was arrested on the basis of the
Now,
your
since
lordship.
when he is in custody?
Lordship.
Since when he is in custody?
Since your lordship 5 2025. Married the FIR.
In the intermediate competent.
Lordship. But no, it was not recovered from him, your lord. From other person, your lord. He was arrested on the basis of confession of the main accused, your lord.
25 is also there, no?
25, but
25 is also there.
yes,
And
your lord.
EPS 25.
But it is recovered from the house of the main accused, your lord. Not from my house, your lord.
Let us
I have nothing to do, your lord.
see the conclusion. Well, it can. After vacation only, I think. Great. Is it in the 20 24?
No.
Right, item number 3 and 8, notice not required, no notice.
No?
Notice, the POCSO is there, so notice may not be required. Or we'll have to take steps.
No, we have already passed the order of notice also.
Notice also.
Yes.
I'm sorry,
Yes.
Lordship.
You can take it by today.
Lordship, in item number 4, there is some, your lordship, typographical error. I may be allowed to correct this error.
There are some.
Typographical error, your lordship.
No, you cannot correct. You cannot correct. I mean, if you want correction, you have to be file an application, and that too. Not
Only
through
date- only date-
handwritten correction is not allowed.
Oh,
Make plea, your lordship. This is a regular bail application for POCSO matter. Accused is behind the bar for last about 7 months. Charge sheet has already been submitted, evidence of victim.
It is before granting bail, lordship. And then straight comes 19/5/2025 and 5/8/2025. Let me look into it. Before
So
that,
before. Yes.
last is lordship, the bail was granted on 23/7 and 25/7.
Yes.
Yes.
Oh.
That's
But the date is 34/2025. Usually course of investigation is going on. Then I have seen, then they jump to 19/5/2025. Two dates are there, 19/5 to 2025 and 5/8/2025. I have not seen the statement or anything. They appear not, I have not seen anything.
Whether the interim order of interim bail is available there?
Yes,
In
Lordship.
the lordship, it is there.
Yes,
But
Lordship.
whether they have appeared or not, nothing is there, lordship may look. In the CD also there. But why they have not written anything about it?
These are the order, I can understand. You were granted interim.
Yes,
that
Lord.
that is there. It is not disputed. In both the occasion, 23.
Or they should take a receipt from the lordship. On other, yesterday lordship, one of the person petitioner has bring that. 34, then comes 19/5. They need to be there, lordship, in the middle of that period.
Yes, bail orders are available.
That is lordship. I don't know why they have not stated they have appeared, nothing is there. Otherwise, lordship, bail is there. Bail order is there. I cannot state whether they appear or not, Lord.
Bail order 27. আৰু 35 হৈছে 1869 the bail order in 2027 are the capital but Mr. AK does did edition BP it is submitted to Mr. Das that the city received and the bail order for the petitioners are also available in the case day. But surprisingly, no statement is recorded. But the statement of the petitioners are not available in the case diary. And the entry of the one entry was of the CD was on 30/04/2025, and then 19/5/2025. That is the prior to the order of interim bail, and thereafter last entry in the case diary is 5/8. But the statements are not available in the case diary. Next product. MS Deka submitted in this regard as per their instructions. Both the petitioners have already appeared for the IO along with the copy of order of the interim rearrest bail, and their statements are also duly recorded by the IO. In view of this, the case diary be returned back with the direction to the IO. Send the updated case diary along with the statement of the petitioners if already recorded. And in case if it is not yet recorded, the IO is hereby directed to do the needful in recording the statement of the petitions. Further, the IO is also hereby asked to take the case diary so as to furnish updated case diary along with statements. Please matter accordingly on 1610.
Actually, a copy may be sharp email.
Copy of the order may be sent to the learned counsel for the learned edition to the need. 1610. Interim be continued. We have recorded that if suppose in any case it is already recorded, then it may be furnished. Or in any case, if it is not recorded, then I may ask you to appear, you appear, and accordingly your statement. So, 59. Anyway, okay.
Plus lunch.
Thank you so much.
Have you already?
Not a full minor.
Oh, not
Go through that minor. My lord, there is a record is voluminous, my lord. That is to find out. I need some time, my lord. Otherwise, my lord, allow us the next date, my lord. If my planet.
This is the third time. The first time they have sought for to study the TCR, and the second time the case was left over. It's the third time, my lord. There's nothing, my lord, it's a non-furnishing of ground. And my lordship is already is aware about the case.
At 2 then?
And before that, my lord, if we can go through.
Okay, okay. Don't bear with some time. They've not been able to just say. Actually, Mr. Pusha was asked for some more time, but he is thought that he
My
had
lord.
already been there, then that's why we call for. After some time, at about say 12, 10, 12, 15,
My lord, fine.
12, 15,
15.
or 12,
My-
15.
Okay.
We call it here.
Okay. Huh?
Please.
19, you were on interim, I think. Huh?
Lordship,
You were on
interim is there, Lordship.
Let's CD receipt.
Yes.
Lordship, in this case, main fact of the case is the daughter of the informant has a love affair with the accused person. Initially, both of them the love affair. So accused is not accused. But the proposal of the informant's daughter, she is not in the age of marriage, Lordship. But even after that, firstly, daughter of the informant has forced me, but the Lordship, but the informant is not age of 18. So even after, the daughter of the informant lost the affair, Lordship. Lordship, finally,
Who lost
paragraph
the
6,
daughter?
Lordship.
Daughter lost the affair or informant?
Lordship,
Father lost the affair.
yes, Lordship. Daughter of the informant.
No. Who lost the affair? Father lost.
Father, yes, Lordship.
No, why lost? Why he lost the affair? Why?
Lordship.
Why he lost the
Lordship,
affair?
kindly paragraph number 6, Lordship. I have mentioned, Lordship. Lordship, daughter of the informant had to laugh affairs with the accused. Even her father insisted the accused should marry her, Lordship. The accused always denied the proposal of the informant and his daughter. She has not attained the age of marriage, Lordship. Being offended, the informant has lost affair against me, Lordship. But the main fact of the case is that the affair is page number 9, Lordship.
As per affair, she is more than 17.
Yes, Lordship. 17 years, 5 months. Lordship.
Yes, question.
My lord, here, my lord, interim granted, he appeared, my. Police says a birth certificate, my lord. And I think, my lord, on the last occasion, the statement, 183 statement of the victim was not with us, my lord. Now that is very much available. And along with my lord, 183 statement of the, my lord, that is a girl, my lord, who was at that point of time in whose residence, my lord, she was, my lord, found, my lord. That girl's statement is also there, who's a friend of the victim, my lord. And those statements are there. And on the date of occasion, my lord, that is as per my lord, that is a 180 statement, my lord. That is the date of incident is 17/1/2025, and on that day, my lord, her age is 17 years 8 months, 15 days, my lord. And my lord, there's a date of birth is my lord.
Recording.
My lord,
On day of recording her statement.
my lord,
Number 19. I'm extremely sorry, Lordship. It's on page number 19, Lordship. Page
Paragraph
number,
17,
page number 19, paragraph number 23, Lordship.
Page 19.
Yes, paragraph number 23, Lordship. That a voluntary statement was recorded by Vijay Gupta under section 300 NDPS Act. In his voluntary statement, Vijay Gupta was confessed.
5 minutes. 5.
Yes. Can do it. Voluntary statement, Lordship.
Yes.
The voluntary statements are recorded by Vijay Gupta under Section 67 of DPS Act. In his voluntary statement, Vijay Gupta was confessed he is a driver since 20 years. Vijay Gupta stated that he met one person, namely Sheikh Hopin, 1 month ago. And Matri Pukri at that time, Sheikh Hopin was told him he is involved in illicit trafficking of the heroin, and Sheikh Hopin also asked to Vijay Gupta if he carry heroin drugs with him by Vijay Gupta vehicles. Lordship, by Vijay Gupta vehicles, I repeat this line, Lordship. Sheikh Hopin will pay Vijay Gupta rupees 10,000. Rupees 10,000 on his proposal. Vijay Gupta agreed to for a tapling of the monetary benefit. On dated reason this, Sheikh Hopin called the Vijay Gupta on his mobile number and told Vijay Gupta to come to his house at Damdai, and also told the Vijay Gupta to go to the Guwahati with Sheikh Hopin with the heroin conceals in false cavity in Marti number reason this. They both they both left for the Guwahati at about 14 hours, and on 31/7/2023 from the Sheikh Hopin house at the Damdai, Tarolong, and reached at Dimapur, Nagaland at about 22 hours, and stated it at a hotel Galaxy at Dimapur town for night. On dated 01/8/23, they Sheikh Hopin and the Vijay Gupta left for the Guwahati from Dimapur, Nagaland at about 500 hours, and they, Sheikh Hopin and Vijay Gupta, are reached at Goswami Lodge at about 16 hours, 01/8/2023, and Sheikh Hopin and Vijay Gupta were booked a room number 16 at Goswami Lodge near Downtown Hospital, Guwahati at 19 hours. Sheikh Hopin, along with Vijay Gupta, took 59 shops cases concealed in the Maruti and kept in the wardrobe in this Lordship. Your Lordship, entire in these things, Lordship, they are coming from the Manipur to the Guwahati. Attached is showed that I have an intention that come with the safe copy and took him to the Guwahati in my car. This is having a statement, this Lordship. Lordship on page number 11, Lordship. It is clearly that he offered Vijay Gupta car, Lordship. On page number 11, Lordship, paragraph number 9. Below part, Lordship. Below part, they stated that the Maruti Gypsy belongs to the relative, namely Kimsi Hockey. That is, the car belongs to the Sheikh of inside, Lordship. The car belongs to Sheikh of inside, his own car, his relative's car, Lordship. He only offered Vijay Gupta that instead of becoming a driver, and I will offer you to 10,000 rupees for your service, Lordship. This is having a thing, Lordship. Here, Lordship, my name involved in this case, Lordship. They booked a room. They booked a room in this case, Lordship. But that very room is booked in the name of the Sheikh Hopin, Lordship. Is it clear in the tribe, Lordship? Sheikh Hopin, this is a single room, Lordship, booked in there, and he's a driver. The hotel offered him a room in the below type, Lordship. Now, Lordship, what's happened? We bought the person, and that time, Lordship, when the investigation department went there, Lordship, we bought the person out in that very room, Lordship. Only this is having my thing, Lordship. The thing is that, Lordship, I'm not entire any having, my past is also there, not, Lordship. I'm 20 years, I'm having a service of the driving, do not have any lesson. Last 1 month ago, Lordship, I meet with that, Lordship. Only thing is that, Lordship, knowing him from the 1 month, it is not having a surprisingly that one person is coming and 1 month ago I meet with them. He operated me as a driver because I'm a driver, Lordship. He operated me, but these things comes out that, Lordship, I am also a member of the leadership where I have a role with the supplier, where I have a network to that, Lordship. Entire the things is operated by the co-accused, Lordship. Entire the things, Lordship. And due to that, Lordship, I'm last 2 years behind the bar, Lordship. And in this case, Lordship, Lordship, charge was framed on dated 23/02/2024, Lordship. Charge framed, Lordship, and complaints were lodged on 25/1/2025, Lordship. And out of the 7 witnesses, Lordship, 4 was examined, Lordship. And the last witness was examined, as I stated, Lordship, on the May month, Lordship. After the having of the 7 occasion when witness, my submission is based on that, Lordship. When we are going to do embargo of the 37, Lordship, then two things comes out, Lordship, whether I have a direct role in this
Okay.
illicit business or not, Lordship.
So your final complaint filed on 25/1/24,
25.
1/24.
Yes.
Charges frame on 23/2/24. After that, Lordship, on 18/4/24, Lordship, 2 witnesses were present, but counsel for the accused persons are not there, were not there. Again, on 2/5/24, 1 witness was examined, but Lordship, counsel for the petitioner was not there, but was not present, Lordship. Again, on 9/7/24, Lordship, witnesses were present and they were allowed to go back because Lordship, counsel for the opposite party, accused persons were not there. 5/8/24, Lordship, same, Lordship. (22/10/24), Lordship. And then Lordship, 16/1/25.
22/10/24 also same.
Same,
Is
Lordship,
present.
same, Lordship. And then Lordship, 16/1/25, Lordship. PW3 examined, none appeared for the petitioner, Lordship, Vijay Gupta. His cross deferred on that day, Lordship. So Lordship, this is the status, Lordship. 4 witnesses have been examined out of 7, Lordship.
With due respect, Lordship.
And Lordship, regarding role, Lordship, regarding contraband was recovered from the lodge, Lordship. He was there inside the room. He opened the door. He opened the wardrobe, Lordship. It is clearly mentioned how contraband was recovered from them, Lordship. It is clearly recovered, mentioned in page number 40, which is seizure memo. He was caught red-handed, Lordship. He was there inside the room, Lordship. Sufficient materials are there, Lordship. And I have already submitted, Lordship, regarding Lordship status of the trial, Lordship.
Lordship, in this case, Lordship, 2 accused are there, Lordship. And this is happening there, my side committed that from my side, that whether before Vijay Gupta am appearing there or not, whether I'm taking the cross or not, there, Lordship. But 2 advocates are there, Lordship. One is from the safe copying also there, Lordship. Here, Lordship, I stated, only having the my part, Lordship, I am declining the cross. Declining the cross, Lordship, only having a thing is that not any my name is mentioned in their Lordship. That's why we are declined the same, Lordship. This is not having necessity that that very thing is going for the only having the safe copying, Lordship. Lordship, from having the 7 from 0 to 5 2024, Lordship, only having a reason of that, Lordship, the council was not present, then whether the witness were present in the court or not, this is having a matter, Lordship. Now here that, Lordship, my only having a short
No, no,
submission.
the dates we have mentioned, whether those PWs were present on those dates.
Lordship, PW, so witnesses were present, Lordship. I will flag my Lordship.
Lordship, I have a one submission there, Lordship. They have stated in the CDR, Lordship, my allegation there, Lordship, I have a link with the supplier. I have so before the court there, Lordship, their own submission there, Lordship, with the supplier. Yes, I have a link, Lordship. I have a link, I have a in my contact number, Lordship, with having a safe copying, Lordship. But as I about this page, Lordship, clearly stated Saruk Khan and one this Kiki, they are supplier and the receiver. Whether, Lordship, I have any link with the other person. Only they proved the CDR that I have a link with the one supplier. One supplier is who? The different person. I have, yes, on CDR is present that I did a call to say copy because he booked me as a driver. If any extra Lordship, anything should comes out that I have a link with any person, the person those who have a suspected of this case, Lordship, this nothing mentioned in the CDR. Only everything based on the CDR, Lordship. And thing is that I'm inside the room at the time of that, Lordship. I opened the door, Lordship. If in that very period of the time, Lordship, if the hotel person was also in that very room, if he opened the door, Lordship, these are becoming the accused of this case, Lordship. Only the basis of that. They make this, they frame that, Lordship, I'm having the consent. Coming from that, if I have a consent, I have any backgrounds, Lordship, related to the case, Lordship, or even I have a link with the other person, such of their Lordship, then it became something, Lordship. 1 month ago, I have a contact with the safe hopping. Safe hopping contact number comes in my mobile, Lordship, and I did the call to safe hopping. This is my submission, Lordship. Lordship, only on the basis of the Lordship, like the pretense also there, Lordship, and the basis of the death, Lordship, I'm innocent person, Lordship, in this case, Lordship. Any conditions, Lordship, not been that, Lordship. I have an annex on medical also report there, Lordship. My wife's father expired, Lordship. I'm not able to give any support to my family also there, Lordship.
Of
I'm obliged, Lordship.
Highly obliged.
Please, Your Lordship. In this case, my lord, I do not get the update instruction from the client, my lord. I could not contact with the client, my lord. What is the present status, my lord, regarding the permanent alimony, my lord, whether the payment is made or not, I could not contact with the, some more time is required, my lord.
Lordship, here the I'm appearing on behalf of the respondent as a legal aid counsel, Lordship. As per my instruction, the petition, and also Lordship may found that they are already, it has become a dead end to their marriages. The respondent had also in his examination and cross-examination stated that he is also not interested. Then they have again filed this challenging the decree of divorce, Lordship. Only thing is that the Honorable Court had found that to give 1 lakh permanent alimony, and they took 4 months time to pay that. But instead of paying that, this criminal revision petition has been filed. But now my client wants to move forward, Lordship. So pendency of this is creating problem because Lordship may found, Lordship, in so that from the judgment also, Lordship, that he is also not interested to continue with the marriage. In that case, Lordship, there is nothing remains in because as per my client, he had already married also, Lordship. Lordship may kindly come down to page number 18 of the judgment, the relevant page.
The
18.
last occasion also, you were asked to file all the supported documents. Have you filed this?
No, my lord. Last,
Huh?
on the
Last, so far, the order says that her so and so now submitted that the petition is supportive with only the judgment passed by the landed trial court below, and other relevant documents are not annexed along with the petition, and accordingly submitted that the petitioner may be directed to furnish all the relevant documents, including the written statement, etc. Provided it is submitted, although there is no stay order passed by this court, but the petitioner submitted before the landed trial court that there is a stay order. They are not, and so stay order was not there.
Not. But otherwise, Lordship is pending. And Lordship may kindly come to page 18. There, Lordship will found that on the basis of what the judgment has been
But on
passed.
the last occasion, it was directed the principal judge that he is at liberty to proceed with because there is no stay operating.
Lordship.
So-
But now it's a final order has been passed, and this is against the decree of divorce, Lordship.
No,
Decree
no,
on contest.
this criminal revision petition is filed challenging the judgment, is it?
Yes, yes.
No, but regarding the alimony part and all, there was no
Alimony-
stay operating.
Yes, Lordship.
Then why it is not there?
In fact, Lordship, my that because I'm only legal aid counsel, I have not that instruction. Why not? They have not perhaps done there for any
So
execution.
now what is your problem now?
my lord, I even not get the updating instruction, my lord, from the client, my lord. What is the status? What is the present status? What is, my lord, I didn't get any contact with the petitioner, my lord.
You don't have any instruction regarding the payment of alimony and
No
all?
payment was made, but they, what is their stand is that in the they want to dispose of this case because they want to move forward. Payment they required as per direction, but if not at all, also then also, but they don't want to continue because it's not possible to continue the marriage. So it should be this criminal revision petition should be closed so that that decree can be removed,
Decree of divorce.
which has been granted. But they, Lordship may come to order that page 26, in the result, the suit of the petitioner is decreed on contest, and the marriage between the petitioner so-and-so, solemnized on so-and-so, and dissolved forthwith. Further, respondent is directed to pay rupees so-and-so to the petitioner as permanent alimony within 4 months. So they have challenged this. Although no stay order is there, but the petition is pending here, Lordship. That is the difficulty. And
So you are not against the order of divorce?
My lord,
You are not against the order of divorce?
my lord, I am only my lord, permanent alimony, my lord.
You are only on the permanent alimony?
Yes.
So even if you don't want permanent alimony now?
if paid, that is better because he was married. That is why the honorable trial court had given it. But if not, also then in any case, Lordship, but they don't want to continue
Which process?
That is the extreme situation, but if granted, that should have been paid, Lordship.
Can do one thing. If it is that be the position,
Right.
suppose, I don't know whether there is any
Yes,
payment
yes.
or not. Or in fact, as you have submitted, even if there is no payment,
Yes.
your petitioner or your client respondent is ready to accept the decree of divorce even without the payment. So in that case, I think it may be before the mediation.
Lordship,
It can be.
so but they has to come, Lordship.
Yes, what is your say? You could not even contact with your client.
My lord, sorry, my lord.
You could not contact with your client.
My lord, yes, my lord. I did not contact with the client, my lord. That is the problem, my lord. What is the status, whether the girl is married or the payment is made or the payment is not made, my lord?
Payment is
Ye-
not made at my instruction, and as per this petition, he could have contacted because he is appearing as a counsel. I am a legal aid counsel, but he is appearing as a counsel and his address is very much there. So definitely he must have any contact with his client. So they are delaying the matter because he is also not interested to continue the marriage from the evidence is reflected.
You are Mr.
W. Rahman, my lord.
Mr. W. Rahman, and Counsel. Bishop the language legal aid counsel for the for admission hearing, but it is submitted by Mr. Rahman that for last 7 months he could not make any contact with his client of the petition, and hence he is not in a position to say anything in regards to this, even in regards to the status of the case. Next, where MS Sharma, the learned legal aid counsel, submitted in that as per instructions, they have not paid any payment towards the permanent alimony. But she submitted that the respondent is ready to accept the decree of divorce even without the payment of the permanent alimony, and to her instruction till date, there's no payment has been made towards the permanent. Mr. Rahman accordingly submitted that as he could not make any contact with the petitioner, he is not in a position to say anything to the status of the case. However, considering the submission made by Learned Counsel for the Learned Legal Aid Counsel, it is seen that the matter may be referred for the mediation, referred for the mediation, and accordingly, let the matter be listed. Can you, if you have any contact, then we can.
Or Lordship may fix
before.
the date here, Lordship, because he can, if he is not willing to, that can be done. Mediation will take more time, Lordship.
Now, what I have understood, but question is that
My lord, date
you
will
are
fix.
you are not against the decree of divorce.
Yes, ma'am.
You are not against the decree of divorce. I have not gone through the case record, but from the submission made by Ms. Sharma. So you are only subject to this payment of alimony.
Yes, my lord.
So now they are in a position that even if suppose you are not have not paid the alimony, but still they are ready to accept the decree of divorce.
Yes.
As that does not want to drag the case further.
Yes.
So that is her information. So in that case, if your client is also ready, suppose for any settlement in the sense, if they are not interested to proceed with the for the non, if they are not claiming at all the permanent alimony, in that case, obviously there may not be any reason for your client or petitioner to accept that proposal.
Yes.
So try to make contact with your petitioner. We are listing it obviously after vacation we'll do, I think before vacation it's not possible. That apart, we are fixing a date only on say 15/10. Try to make contact with your client.
Yes, madam.
And if the matter can be disposed of in the court itself, it's very good. Because otherwise, if you don't have any issue on the permanent alimony, or rather if they are not claiming, then it's okay.
My
You
lord.
can accept the, well, then you can forward in your own life.
And a fixed date.
We are listing it on 15th. Just take the instruction that let us know what what is the status of the case, or if your client is not also interested, and definitely, because she is very clear that even if the payment is not there, then also she is ready to accept the decree of divorce.
Yes, ma'am. Yes, ma'am.
15 seconds.
Okay.
Okay.
Please.
Yes.
So as per the last order dated 23/6/25, we had taken steps on 27/6/25 in this present case. Against, there is only one respondent here.
The complaint case was fixed on 9/7.
Yes. Your Honor, now the next date is on 15th November.
It's basically NI case.
And I get.
So they keep- So 9/9 again, notice was issued.
Yes, Your Honor, on 27/6 we had taken steps.
20?
27/6/2025. And earlier also there was a Section 5 application connected to this case. We had taken steps. Also, they had refused to accept the same. And when on the last day, the Honorable Court had directed us to produce a copy to the other side in the trial court, but they had refused to accept the same. So we had taken steps by post as the court had directed.
But they are appearing before the learned trial.
Yes.
court. They are appearing.
There.
Then why they are not ready to accept the notice?
Even when the Section 5 application was going on, so as per the Office Note 85/25, it had gone unserved, refused, and returned to the sender. They refused to accept the same. And in the trial court also, when we had served them the copy, they refused to accept the same.
So sub in regards to Section 5 only.
No, this present case.
In the present.
Yes. As per the last order, we were directed to give them a copy in the trial court also. Thus, we had taken steps.
For trial court.
Yes.
Wait, wait. Check on date first. Okay, very good. So that order was passed on 23/6/2025, whereby you were directed to serve a copy personally to the other side.
Yes.
Now you are saying that they have refused.
Yes.
Thereafter, you have taken steps.
Yes, on 27/6, we've taken
27/6.
27.
So not 27/6, 8/7/25. As per office, note. I'm not.
We had submitted, it must have come in the Office Note later.
But that is still abated.
Date maybe fix after vacation. Any date after.
Or in the next date, you may make a file and we're not going to reflect in the order, but I'm just saying. You may make a application, interlocutory application regarding or an additional affidavit stating that they are not accepting.
Yes.
Even if the council is also not accepting.
No, you know, council is only when he had appeared before the trial court, he was not accepting.
Yes, trial court before
Yes,
trial court.
yes.
So both 11 and 12 are connected, or?
Yes, connected case. The date may be fixed after vacation, any date.
11 and 12. You are Mr. Senso?
G Kaushik.
G. Kaushik. Heard Mr. G. Kaushik. He done it. As per order dated 23/6/2025, the petitioner was directed to serve a copy to the respondent side before the trial court, as the date was fixed before the trial court on 9/7. It is accordingly submitted. Mr. Kaushik said in person to the said order, they have also they requested the petitioner to receive the copy of the petition, but in fact they did not refuse, they did not accept the notice, and for which the petitioner again took steps to register AD on 27/6/2025, which is still awaited. Post from office note dated 9/9/2025 with triple stamp. The notice was issued to the sole respondent to register AD on 8/7/2025, but neither the AD card nor unsub notice is received back by the section. In view of this, let the service be awaited till next date of listing. List matter accordingly on 15/10/2025, awaiting for the service of the sole respondent. Okay.
Should we file our affidavit in this case? It's yet to be tagged along with the case record. The morning itself we have filed our affidavit in opposition. And for the respondent number 2, the complaint.
You've already filed the affidavit today.
Yes, today. They have received the
Today
copy.
morning, we have received a copy of the.
We have, it is not yet tagged with it.
Yes, it is yet to be tagged, the case record.
Do you want to need any date? No.
Date for hearing.
Date for hearing, it may be taken up for disposal because already the
Yes.
complaint case is pending before JMFC and Amingao. So Lordship, already 2 years have been already passed and still the case is fixed on appearance stage and there is no interim on their part. So maybe,
It may be finally heard.
yes, it should be finally heard.
Finally.
Because issue is very limited here and in our affidavit, we have briefly stated the points. So it should be taken up for final disposal. Fixed date may be given after.
You're on 30th October is the next date in the trial court. Before that, any date?
30.
30. 30th October is the next.
But Mr. G. Kaushik will learn it for the petitioner. But Mr.
P does.
P does. Counsel for the respondent number 2, Mr.
G Kaushik.
R. KK does the learned additional paper for distinct. It is submitted by Mr. Das that the morning only we have filed their affidavit position, which is it will be tagged with that apart both the counsels for the petition and the respondent submitted that the matter may be listed for final hearing and may be decided upon. In view of this, listed matter on 16/10 we do 16/10 for final hearing. The registry is hereby directed listed matter. It will be listed in the hearing column only.
Yes. Much of it. Much.
His 17 was earlier rejected.
Earlier rejected.
18 was not there.
18 was not there. Fresh application.
It is a fresh petition.
Fresh. 17, my lordship, petitioner was arrested on 20/10/2024. As on date, 10 months,
2808.
20/10/2024.
20.
20/10/24. As on date, 10 months, 22 days. And item 18, my lordship, petitioner was arrested on 04/01/2025. As on date
04.
04/01/2025. As on date, 8 months, 7 days till today, my lordship. Charge sheet has been filed. Filed on 18/01/2025.
Hmm.
5 accused has been charge sheeted, my lordship. Out of 5 accused, 3 accused has been granted bail by this honorable court. The case is now in the evidence stage. Out of 50 listed witnesses, not even one have been examined.
How many? 50.
50. 50.
150.
50. Not even one have been examined. Here in the both bail application, we have taken the plea of non-furnishing of ground of arrest. It is in notice under section 50 and also in the arrest memo, my lordship. My lordship will find notice at page 66A. That is item number 17. There is Songja, bail petitioner Songja Rompi.
66.
66A, page 66A. It is a notice. Only the section has been registered section has been given and ground has not been stated. And the next page, my lordship, that is 67. This is annexure 5. 66A is annexure 4 and 67.
It's an arrest memo.
It's an arrest memo. Here also, ground has not been stated. And in item number 18, page 66. Page 66, this is a 50-year notice, my lord. Same. And 67 is the arrest memo where ground has not been stated, ma'am. My only point is that non-furnishing of ground of arrest in the arrest memo as well as in the notice issued to the petitioner under section 50 CRPC. It is a clear violation of the mandate of Article 21 and 22(1) of the Constitution of India. A co-accused has been granted bail. 3 co-accused has been granted by this honorable court. And out of 50 listed witnesses, not even one have been examined. And already they have been in jail for many days, my lords. That is my only prayer for consideration of bail. And also, my lordship, that both the petitioner has applied for bail in the learned session judge, Ipu Karbi Anglong. Bail rejection order is there. I want to. Page 81, my lordship. Item 17, page Songja petition. The same way.
81.
Page 81A. Annexure 9. My lordship. The public prosecutor, this is the bail application for accused Songja Rompi, Elise Chengpi and Bibishan Karam arrested in connection with Dipu PS case number 39 to the heart both sides. The public prosecutor has pointed out that the Honorable High Court has already rejected bail application of the accused Songja Rongpi in this case, while High Court bail application number 549/2025, order dated 28/04/2025, and therefore, according to the prosecutor, the proper forum to adjudicate the fresh bail application can only be before the same bench of the Honorable High Court. Now we cannot, now the petitioner cannot approach the session court
That
also.
is not, that is not.
This is the observation
Here we
given.
have filed in, as per our notification. If suppose bail is rejected by a bench, then definitely if subsequent bail will come before this, before the same bench.
Same bench.
But it's not a case that the learned trial court or session court cannot entertain. But definitely they cannot.
But here clearly they have
Yes, sir,
stated.
they have said it, but I don't think it is a proper submission or proper finding.
Yes.
Because trial court has every right to dispose of. It's not a case that this High Court has rejected the subsequently. There may be many grounds on that ground you can appear or you can miss it. But as per my view, it is not
But
proper.
yes,
correct
yes, my lord. Here the direction was given by the system that only the forum will be the High Court. That
It's
is,
not that. It cannot
Yeah.
be that. That cannot. Anyway, okay.
here I am not on the merit of the case, my lordship. Obviously, there is incriminating materials are there. Also a very sensitive case. A young girl has been died. Limited submission.
Yes, madam. I have gone through my lord, this is the trial court record, my lord, scan copy of that, my lord. But admittedly, but my learned friend has submitted, my lord, the 50A notice arrest memos are there, where, my lord, the detailed ground of arrests are not available. Now, my lord, my learned friend's submission before this honorable court is that after the case of Probir Purkayas of Bihan Kumar, now that is a, my lord, the principle is that clearly laid down by the honorable apex court, that it is a mandate, my lord, to give it, to make the person so that, my lord, it's not prejudiced. My lord, after Bihan Kumar, my lord, before going to the law point, my lord, I'm coming to, my lord, that is the Songja, my lord, that is the item number 17, my lord.
17.
Who is, my lord, Songja Rongpi, my lord. My lord, may kindly peruse the, my lord, scan copy of TCR, my lord, only 2 orders, my lord. Because one order is, my lord, 21/10/2024, my lord. I have a flag mark, my lord, horizontally, maybe, my lord, in the first part it is available.
Yes. Which
My lord,
part?
just 21/10/2024. It is for Songja, my lord.
Yes.
Here, my lord, from perusing of the order, my lord, this come to light that, my lord, he was, my lord, arrested, my lord, by, my lord, the strength of him, my lord, that is a, my lord, transit warrant, my lord. It is from, my lord, the transit warrant, that is JMFC Kanchipuram, Tamil Nadu, my lord. On 20th and on 21st of, my lord, October 2024, he was, my lord, present. My lord, in the next part of the, my lord, that is the, my lord, this is the order, my lord. It also reflects, my lord, clearly. He knows about his grounds of arrest. First, my lord, his arrest is before the, my lord, the learned CGM, my lord, by dint of a, my lord, warrant, that is the transient warrant, which is, my lord, issued from the judicial magistrate of Kanchipuram, my lord. And thereafter, he was presented before the learned court, my lord. And, my lord, he knows about the same, and the learned court, my lord, provided the legal aid defense counsel for hearing is the matter, so that, my lord, the right of his, my lord, to defend the matter during the time of production, that should not be, my lord, that is the restraint, my lord, that was made. That is also available in the, clearly available in the, my lord, record. My lord, may I kindly peruse the order. Now, my lord, in case of, my lord, that is the Bibhishan, my lord, that is a Bibhishan alias Cardom, my lord. It is a, my lord, 18, my lord. That is also another order, my lord. I have flag mark, my lord. On the learned magistrate court, my lord. His arrest was on, my lord, 4/1/2025, brought before the, my lord, JMFC within 24 hours, my lord, 5/1/25, my lord. If my lord may kindly peruse, my lord, in that order, my lord, this compliance of all these things are there. I am not saying that, my lord, that the written ground of arrest is in the 50/50 and arrest memo. That is not. But my lord, he is aware about the arrest. My lord, that is the order, my lord, reflects it clearly. Secondly, one statement from his end that he will engage counsel, my lord, to defend the case. That part is also there, my lord. My lord may kindly peruse that order, my lord. 5/125, my lord, that also I have flag marked, my lord. Division alias cardom, my lord. And my lord, when my lord, his my lord engaged counsel was not appeared before the my lord time of production, my lord, then my lord, learned, my lord, that is the judicial magistrate court, my lord, provide him a my lord legal aid defense counsel, and that was hard to defend his case, my lord. That is also there.
Yes.
Yes.
So in that case.
My lord, that part is there.
She
So,
was
my lord,
not
that is the fact, my lord. Till today, my lord, after perusing of the my lord TCR, my lord, available with us, this is the fact that my lord, the first, my lord, the 50/50 notice and the arrest memo is provided, but admittedly, there is no, my lord, that is the in the written format, the ground of arrest. But my lord, the production order, my lord, it reflects, my lord, three things. One, my lord, that is my lord provided. In one case, my lord, it is the deemed offence, my lord, by the Harso offence, my lord, transit warrant. My lord, he was taken, my lord. Secondly, my lord, he, my lord, was given all opportunity to defend his case during the time of, my lord, production. My lord. In both the cases, my lord. In another case, direct arrest, my lord, by the police, he was, my lord, given that opportunity. So, my lord, now, my lord, after Bihan Kumar, because, my lord, the Bihan Kumar is that landmark judgment, my lord, entire interpretation of law is provided. After Bihan Kumar, my lord, another two judgment, where, my lord, there is the interpretations on the ground of arrest. One is Kasi Reddy, Upendra Reddy's case, my lord. My lord is very much aware, where, my lord, it is clearly stated that, my lord, that is the, if, my lord, it is a, by dint of a warrant, my lord, if the arrest is made, my lord, it is sufficient if he was told. And from perusing of the record in case of, my lord, that is the Songja, my lord, there is item number 17, that part totally completed. Now, after, my lord, Kasi Reddy's, Upendra Reddy's case, what I am relying, my lord, now this is, my lord, this is famous Darshan's case, my lord, state of Karnataka, this is Darshan, my lord. It is on the, my lord, 14th of August, my lord. This is the, my lord, the judgment, my lord. My lord, may kindly peruse, my lord, the my lord, paragraph 20.4, my lord. My lord, first, my lord, from 20.1, my lord. It is internal page 19, my lord. Internal page 19 of the, my lord, judgment is from Supreme today, my lord.
20 point.
Yes, my lord. I have, my lord, that is a tick mark also, my lord. Internal page 18, my lord. 18, my lord.
20.1.
Yes, my lord. 20.1, my lord. Here, my lord, subpara 20.1.2. May I read, my lord, those paragraphs? Article 22(1) of the Constitution mandates no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall be denied the right to consult and to defend it by a legal practitioner who is choice. Similarly, Section 51 CRPC requires that every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds for such arrest. Now, my lord, 20.1.3, my lord. The constitutional and statutory framework thus mandates the arrested person must be informed of the grounds of arrest, but neither provision prescribes a specific form or insists upon written communication in every case. Judicial precedents have clarified that substantial compliance with these requirements is sufficient unless demonstrable prejudice is shown. My lord, our submission from the side of prosecution is this.
after perusing both the production order, my lord, that, my lord, demonstrable prejudice is not, my lord, not with this in both the cases. Now, my lord, may kindly peruse 20.1.4, my lord, because my learned friend is, my lord, relying on the landmark judgment of Bihan Kumar, my lord. That is, my lord, the chronology, my lord, Panchal, my lord, that is there of the Probirpur caste and Bihan Kumar. In Bihan Kumar versus State of Haryana, it was reiterated that Article 22(1) is satisfied if the accused is made aware of the arrest grounds in substance, even if not conveyed in writing. Similarly, in Kasi Reddy Upendra Reddy versus State of Andhra Pradesh, my lord, thereafter, where, my lord, that warrant matter is, my lord, there. It was observed that when arrest is made pursuant to a warrant, here, my lord, in one case, my lord, it is the by dint of a production warrant. Production. Because, my lord, warrant, they have not, my lord, that is, my lord, a transit warrant, my lord, here. That is, they are not, my lord, this is the defining this warrant, that warrant. The word till today, my lord, pronounced by the Honorable Apex Court is the warrant. Reading out the warrant amounts to sufficient compliance. Both these post Pankaj Bansal decision clarify that written individualized grounds are not an inflexible requirement. The, my lord, that is the, my lord, they use the word, my lord, Honorable Apex Court is not an inflexible requirement in all circumstances. Maybe inflexible case to case, my lord, depending on the circumstances. Now, my lord, may kindly produce 21.5. While Section 50 CRPC is mandatory, the consistent judicial approach has been to adopt a prejudice-oriented test when examining alleged procedural lapses. The mere absence of written grounds does not ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of a fair opportunity to defend. Here in both the cases, my lord, fair opportunity was given. They were aware about the arrest. In one case, they clearly state that I will engage my counsel. And other, my lord, arrest part, the 50 and 50A, both are mandatory in the they were given, my lord. One in the by virtue of a, my lord, warrant. Another, my lord, another is also, my lord, the direct of arrest by the police. But both the cases, all compliance were based, my lord. So that was our humble submission before your lordship regarding these two cases regarding non-furnishings of the written form of ground of arrest. Now, my lord, another, my lord, there is submission from the side of the, my lord, my learned friend is that regarding, my lord, that is that there is a, my lord, long list of witnesses, my lord, until today no one is examined, my lord. On the same case, my lord, it is also related to 302, my lord. My lord, may kindly produce, my lord, that is internal page, my lord, 22, my lord. Same, my lord, judgment, my lord.
Same judgment.
Same judgment, my lord. My lord, 21, first, my lord, may come 21, my lord, page 21, my lord. Below, my lord, bottom of the page, my lord.
Yes.
May I read, my lord? 20.4. Filing search sheet or lengthy list of witnesses doesn't justify grant of bail. 20.4.1. It is well settled that mere filing a search sheet does not confer an indefeasible right to bail. Likewise, the mere prospect of a prolonged trial cannot by itself outweigh the gravity of the offense. Here, my lord, the gravity of the offense is there, my lord. Even, my lord, if the PM report clearly, my lord, indicates everything, my lord is aware about the facts, so I am not submitting all those things. The incrementing materials gathered during the investigation or the likelihood of tampering with the witness. 20.4.2. In Kalyan Chandra Sarkar versus Rajesh Ranjit Chopra, this court categorically held that the High Court could not have allowed the bail application on the sole ground of delay in conclusion of the trial without taking into consideration the allegation made by the prosecution in regard to the existence of prima facie case, gravity of offense, and the allegation of tampering with the witnesses by threat, inducement when on bail non-consideration of the same and grant bail solely on the ground of long incarceration vitiated the order. So that's our humble submission before your lordship regarding these two men.
My lordship, I want to submit something. I don't know the citation. My learned friend has cited some citations. I don't know if it will take my case or not. But here in the Vihan Kumar and Prabhat Puskar case, clearly it can be stated that non-furnishing of ground means it's visit the release month of a person. Or it is that it is a accusement. Lordship. Yeah, clearly it has been stated. I am relying on in Vihan Kumar, I am relying on Para 21, my lordship. And in Prabir Purkasto, there is 48, my lordship. Even in our petition, I have stated there. Even my lordship, the out of 5 accused, 3 has been granted by bail by this honorable. That is my humble submission.
I'll pass you.
Problems.
What about 30 to be?
Wait, this is your lordship. Lordship, this is a criminal revision petition against order dated 15/6/23. What happened in this case, Lordship? A divorce proceeding was pending between the petitioner and her husband. In the divorce petition, she had filed an application. In the application in the criminal case, Lordship, where she has stated that at page 19, I have annexed that she is a part-time teacher at a private school. But while annexing the assets and liabilities document, in the assets and liability column, she had just mentioned it as a cross. That annexer A, Lordship, starts from page 19. At paragraph 3, page 19, Lordship will find that the first party is a part-time teacher at a private school. And in the asset and liability column, that Lordship will find at page 26.
Just a second.
Yes,
Have
Lordship.
you taken steps? Steps you have taken.
Steps, Lordship, what here informant is the judge of the family court. He himself had complained it, and Lordship's own order is there that Lordship had expunged from taking any step, because the complaint is filed by the judge of the family court before the CGM that she had submitted false information in her affidavit. So cognizance has been taken, and I'm against that order where she was cognizance has been taken and a proceeding was started in the CGM court as per the complaint of the judge of the family court. So Lordship says that he may not be a necessary party, the judge of the family court. Lordship's order is there while issuing notice, and the state is there, Lordship. So Lordship at this stage may not be necessary. That is what
No,
Lordship's
no.
order.
Where is the husband or the other side respondent?
Lordship?
Husband or the respondent?
No, because we are not against the divorce case. We are only against that CR case which has been initiated as per the complaint of the family court, that she had submitted false statement in her assets and liability or her divorce petition. So Lordship will find that order at page 15/6/23. That divorce case is continuing, Lordship, and we have nothing against that divorce in this petition. Here I am praying for only that.
So now state is the only respondent.
Yes, state is the only respondent.
So what is the stage of the case? That case it is stayed. I think.
Yes, Lordship has stayed this CR case, whereby a cognizance has been taken and subsequently she was granted bail also. Only thing here is that the Honorable Court and the complaint lodged by the family court judge that she had submitted some false information, that is the basis of the case. But in her petition, she have specifically mentioned that she was in a part-time teacher at a private school. Only inadvertently in the asset and liability column, it was stated as cross. That Lordship will find at page
But in this
26.
case, our name does not reflect it, and we don't have the petition also, Lord. The item 33.
You can cross the issue to go person. Malika नाम नहीं देखा वो पर.
Complaint की थी।
Oh.
मैं comment करती हूँ।
Actually, what had happened at the time of filing the assets and liabilities,
Okay, Lord.
there was some question arose that whether this present petitioner had give some false information or he did, and to that extent, some affidavit was also swearing, but with some false information.
Okay.
And the concerned advocate who was there in this case against him and the other case, the Tulanet Principal Judge Family Court was the complaint before the CGM, stating that they have suppressed all these matters and this for that prosecution has to be prosecuted.
Okay.
So in that case, this case is now pending because here we don't have any issue on this merit of the divorce case or the maintenance. But the question is that here the Principal Judge Family Court was made a party. But subsequently, I thought that he, on his official capacity, only passed the order.
Yeah.
Now he may not be a necessary party, so that's why his name has been struck off, I think. And the state is there only. So you are, I don't know, you are ready or not. Because
I'm not.
as part that apart, whether the trial court record is already received, by which the complaint was lodged or where the observation was made by the land
Lordship,
municipal
a
judge.
record possibly not here. Actually, I think I think can
That is the
No,
judicial magistrate Pascal Popular CR 426,
yes, Lordship.
wherein the order was passed, I think.
Yes.
426 record, I think.
Family court का तब बना के कंटेनर कंप्लेन है 10 से private and they are not supposed to this stuff. Issue आता है नाम वो तो issue state होगा सांस से होगा
Tar bis CR case registered. CR 426. It was the it was order. Beleg record. We have not received the record also.
Okay, but we are not ready because our name does not, and we don't have the file also, Lord. Because our name is not reflected, so office did not give us this petition also, Lord.
Obviously, you need that order.
Any data?
Hard MS B. Sharma, Internet counsel for the petitioner. From the order. Also hard Mr. Ticket has done a petition and people. However, it is submitted by Mr. Las that they are not provided with the copy of the petition, and their name is also not reflected in the post. Hence, the additional public prosecutor is not aware of about the present case. Further, it is seen that case record of CR 426 over 2023 is also not received, which would be required for disclosure of the present case. And the further proceeding was also stated.
Yeah, then if it's a first party, the part-time teacher.
By its alternative with one
The assets and liabilities are is cross deeded. Maybe planet family does a all statement say every
the name of the public prosecutor,
they will complain.
the cost is. At the same time, the registry will also take necessary steps following the case record of CR 426 of 2023 arising out of memo number FCB 15 public admin with 2023 slash 465. List the matter accordingly after. Your case has been stayed, I think.
Yes, Lordship, interim order is there.
Interim order is there. So we were listing it after petition.
Lordship, PPSM name may be reflected. No?
I have already directed the registry to reflect your name as well as copy may be served to you.
Previous bill, madam. Hello,
IA for
I for previous bill, previous bill, madam, continue for they passed by the distinct session judge, madam. Lord, matter is this, my lord, generation negligence. My lord, appellant is the auto puller. He has no duty to protect the child, my lord. He took that fare of the tenant, my lord. When they reached the place of his location, my lord, my lord. And then mother and co-pillion passenger and child get down from the auto puller. And after taking the fare, my lord, he went. But that is not duty
so
to
you are
protect the child.
convicted under which section?
My lord, under section, my lord, 279 and 304A, my lord. My lord, prefer the appeal before the distinct session judge, my lord. And distinct session judge, my lord, impose the punishment for under section 279 for 1 month and under section 304A impose the punishment for 3 months, my lord. And against of that, my lord, distinct session judge allow him to go on previous bail, my lord, for 1 month. That should be my humble prayer. That should be continue, my lord. And in the meantime, a warrant has been issued, my lord. And police visited to the appellant's house, my lord. Petitioner.
Have we annexed the order?
Well, annexed.
No, annexed order of wherein you have allowed to remain on previous bill. This order is there.
Previous bill to assign. My lord, kindly page number 20 of the IA petition, my lord.
Yes.
That relevant portion is there, my lord. The record of the learned trial court be sent back along with a copy of the judgment. The appellant accused is to surrender before the learned trial court within 1 month to comply with the judgment. That is directed to comply, madam. The judgment.
Then it was the
Madam,
direction was given on
the
2nd July.
No, sorry, madam. Sorry. That was
2nd July 2024. The order was passed. You
Madam.
were directed to appear within 1 month.
1 month.
Suppose
Against of that,
if you consider
sorry,
it is 1 month, your previous bill is there.
madam.
Then you have not signed that.
No.
And when you prefer this revision petition,
Prefer this against the distinct sessions as well. Prefer the appeal before the Lordship Court, my lord. Appeal number 1 of 2024, my lord.
no, we are not on appeal. In appellate court, they passed the order directing you to surrender before
Sir,
the learned
which
trial
day?
court for serving out this sentence. That is within 1 month.
My lord, I'm saying. Judgment and order dated, my lord, 2/7/2024, page 9, my lord. Of the
No, we are not on judgment. When you filed this one,
this was filed on, my lord.
Oh, therefore setting aside and quashing this order.
Which state of the criminal revision to file for the petition.
My lord, praying for setting aside quashing the order passed by the district session judge, my lord. Order dated 2/7/2024, passed in criminal appeal number 1 of 2020.
They reported it or it filing. If they are reported. Get it.
My lord, this criminal revision is filed on my lord 17/2/2025. Date of filing of the criminal revision, my lord. That is my lord 17/2/2025. It is filed, my lord. 17/2/2025. Criminal revision is filed, and my lord, that is the IA. IA is filed on my lord
CD
1/8/2024.
I 1A
1/8/24, my lord. It is shown as 1/8
prior filing or what?
prior to filing. Because IA is my lord here 1022/2024, my lord.
My lord, actually, before filing this revision petition, my lord, one criminal appeal has been mistakenly that one criminal appeal was filed. And that was withdrawn and filed this instant petition. Mm. Appeal to me.
Itu kami tim detektif participation So Pushpa, we have seen the record.
Yes, ma'am.
It seems that it was filed on 1/8/2024 itself, but there was some defect.
Yes, my lord. Some
The
defect was there at
corrected.
that time.
And
lord, appellate
accordingly
court's order
corrected
was-
on 29/10/2024, that is in October.
My
And thereafter it was registered most probably subsequently on 25, I think.
my lord. My lord.
Maybe,
My
as far as I think so.
yes.
But now against you, the warrant of arrest has already been
My lord.
issued.
My lord.
We can recall and give them the bail.
Because my lord, appellate court's order was passed on 22/7/2024. And my lord, that is IA. Maybe of defect, that is a different thing, but IA was filed on, as per my lord, the record available in this my lord network, my lord. It is from where I got my lord. That is, it was filed on 1/8/2024.
Yes.
That means my lord within the time frame. Because my lord, my learned colleague's submission is that at that point of time he filed his criminal appeal, and because
There
of
was
the
a defect.
reason, my lord, again he has to go for a revision petition. My lord.
Yeah.
Yes, but IA, that is the main purpose of the IA for to go on previous bill. That is filed within the period.
Previous bail too, we cannot allow at this stage.
Yes,
Yes,
ma'am.
warrant has already.
Yes, my lord, warrant has already,
Already
my
there.
lord, already.
He has to go for fresh bail.
My lord.
One Mr. B. Islam, the learned counsel for the I do. B. Islam for the counsel for the petition, and Mr. K. Bush, learned Islam. It's an application, section 389 CRPC, player to also to allow the petition to remain on previous bail as granted by the High Court later. And also for the suspension of sentence passed in passed by London District and Session Judge Morika in criminal appeal number 1 of the 2024 visa is the order of conviction passed by the learned Original order was passed by whom? CGM or?
My lord, judicial magistrate first class, my lord, Morigam.
Judicial Magistrate First Class in PRC case number
In PSC
445.
case, my lord,
445 of 2020.
445 of 2020.
Which date it was?
That
Order of date of order?
date of order, my
judgment?
lord,
27.
27/12/2023.
Sabit Solik,
It's more to clear.
On that challenging the impugned judgment and order passed by learned GMFC in PRC case number 445 of 2020. He had preferred an appeal before the learned district and session judge Morigao. And after hearing the appeal, the learned session judge had appealed the order passed by the learned GMFC, whereby the accused was convicted for a period of 4 months in respect of offense under section 279 IPC and 1 month SI for section one for 279 only 1 month SI out 304A IPC 3 months SI. Because it is also some time Mr. that within a whole period of limitation, the connected criminal division petition was also instituted, but due to some defect in the filing of the case, it was subsequently corrected, and then it was admitted, and then it was subsequent, and it was corrected and then it was registered accordingly. But it submitted that as the petitioner could not appear of its surrender before the learned trial court below, the warrant of arrest has already been issued against him, accordingly plea for suspension of sentence, as well as to remain the petitioner on his previous plea. Next one, Mr. Posture, given a petition will be raised or submitted that petition may be considered. However, the prayer of previous bail may not be considered at this stage, as warrant of arrest is already issued against the petition. Next one, here it is submitted made by non-considered. The petition is allowed, and the impugned judgment and order dated to 02/07/2024 passed by Thane District and Session Judge. No, impugned sentence passed by the Thane Session Judge in criminal appeal number 01 of 2024, as well as the sentence passed by the learned GMFC in PRC case number 445 of 2020 is hereby state of suspended till it goes out. The connected revision petition. Further, petitioner is hereby allowed to go on fresh bail to the satisfaction of learned JFFC Morigao for an amount of rupees 20,000 with 1 seat to back. If I share of variable disposal out of criminal division. Criminal division, you have not taken steps?
Steps has been taken, my lord, on 16/5/2025.
Your state is only party, or one informant is also a party.
My lord. May respondent number 2, my lord.
Heard Mr. P. Council petition and heard Mr. A. Bush regarding the legislative. As per this note, dated 9/9/2025, the service on respondent number 2 is still awaited. Let the service be awaited with next economic. Also call for the TCR of both appellate court as well as the learned trial. This is the matter according to courts as an
Chief.
But you provide us the compliance
My lord.
after furnishing the bill.
My lord. Development. My lord. Here,
Actually, just a second. In the morning hours, it was mentioned by, I don't know.
But without informing us, we have not informed, we are waiting.
Yes, then I asked that you just inform the other side.
Not informed.
But
Well,
in the
he-
morning hours only they
Yes.
come and requested for an adjournment, then I said that you just.
But it is, they should inform us, we are waiting here till now.
Oh, no, but he said that he tried to inform one Miss MS A Hussein.
Why he
Who
had
is
not
you-
me,
You are himself?
I am here, my lord, and I know him very well. He know also, we are belong to same chamber. Why he is not approaching me, my lord? And I know him very well. He will not approach me, my lord.
But whatever maybe, but request was definitely made before us. Because they have filed, the transfer petition was filed by them and you were the respondent.
Yes, my lord.
And subsequently you have filed one IA.
And also affidavit I also file. I have filed for beginning because entire proceeding has been stalled. I file I get a case in the jurisdiction of district Mangaldoy. Now they want that it should be transferred to Barpeta. I am a lady, and the petitioner said he's want to case should be transferred to Barpeta. I am a lady. My husband expired. I have no income, so how it is very difficult on my part to if we want
You
to.
are a accused or a complainant?
I am the complainant. I filed a NIA case, my lord, and they are the accused in that case. Now they want that should be transferred because they filed a title suit in Barpeta. This is another different matter.
But what to do?
I have no objection if he informed me. I have no any objection. And we generally not make any objection if anyone agenda. It is his duty to inform. From the very beginning morning, we are waiting here, my lord. What is it? That may be observed. That may be observed, and it matter be fixed on the Monday or Tuesday. We have no objection. Tuesday it may be fixed, my lord.
Do you know his name?
I know. B.
No,
Hussain.
do you know his name?
Yes. Billal Hussain, full name.
B. Hussain.
Yeah. His full name is Billal Hussain.
Oh, he is B. Hussain, na?
Yes. I know him very well. Yesterday I will meet him.
That should not be. That's why I just asked in the morning hours also. They should
No,
just inform me. And
why
that
yes.
I have just.
He is not. I felt he is not informed.
Yes, no, I was thinking to cooperate him also. That day I asked Mr. Borwa also.
Well,
That if they appears and if they consent, then will matter may be taken up.
yes.
That's what also I'm saying because in the morning hours there was a prayer.
My lord.
Then he's.
So, my lord, fix on my Tuesday fix, my lord.
Contact.
Tuesday fix.
Heard, no, none appears on call for the petitioner.
Petitioner in petition revision.
Yes, transfer.
The transfer petition. And IA he is responded.
In transfer criminal, like none appears on call for the petitioner.
No. In application, I am the petitioner.
GMI did not consider the response public petitioner in IA.
Yes.
Criminal 477 of the in the morning hours, in the morning hours, one Mr. B. Hussain, the learned counsel for the petitioner, prayed for an adjournment, wherein he was asked to inform the others, but without any information. The learned counsel is remained absent when the matter was called for. In view of this, that the matter be listed, or you want to, Tuesday, I cannot say, Tuesday is 16th.
It may be also Thursday maybe also. 18.
Okay, list on.
Generally, we are not objectors in such payment.
See, generally, you people.
Yes.
Generally
We are,
are
I am
advocating
unnecessarily.
to oppress with the other.
Unnecessarily, I am waiting here. Madam.
Yes, obviously. To cheer. Okay, well, let's take it further.
Hello, blessing.
Yes, 30.
May I please the Lordship? Lordship, in this case, what happened, it was last listed in 14th of July. And my junior colleague had taken time pass over this matter. So in online, it is nothing has been shown whether notice has been issued or not. And this matter.
You are the better person to say whether notice we have taken steps or not.
My lord, it was time being and the court was early.
No. You don't know whether you have taken steps or not.
No, we have not taken steps. And the thing is that in this case, on merit, my submission was not recorded since it was passed over for time being. So I needed some, in this case, some interim orders also. If it is notice has been issued, if it is issued, then I have not taken any steps because
Why you have not pressed for any interim?
it was for time being. My junior colleague had passed over this matter for time being, and subsequently this matter. Yes, issue which we can take on phone.
steps
No, step one.
step notice करेंगे
No, order.
Why not?
My lord, this matter supposed to come in motion column.
Order.
An order, Mr. Bosak.
You're not taking steps now. You know, my lord, he used to take steps. What I understand is that, my lord, on that day, my learned colleague was not present. On his behalf, my lord, another person appeared.
My junior
My lord, his colleague appeared. And my lord, because my lord, the order is not uploaded in the online, my lord. He is not able to know, my lord, whether, my lord, at that day, my lord, the matter is passed over or my lord, order was passed. Now he has come to know, right now, my lord, going through that. Because it is not available in the, my lord, that is the
online record, it is not uploaded.
That is something. So let him take us.
We upload every order.
My lord, I have some.
Signed, especially if it is signed by.
Yes.
Then all the orders.
My lord, sometimes, my lord, it is available in this, my lord, local area network, my lord. But sometimes it will not come in the, my lord, that is that portal, my lord. Sometimes it happens.
No, still date, as on
Not
date,
always,
it's
my
not
lord, but
available
sometimes.
online.
Maybe
And,
that reason, now, my lord, he has to take the steps then.
my lord, like, my humble submission can be entertained that in that case, on that day, I could not make my submission, but in this case, an stay is needed in a proceeding is going on in the lower court.
The postponement of proceeding without hearing, my lord.
No, it's postponement of proceeding.
Yes,
Yes, my lord. If my lord pleases to the charge sheet in the FIR, whatever sections are mentioned,
It will be.
all the sections are dropped. All the
order
sections here dropped and given all of a sudden 498A. Can you find please, sir?
No, we are not going to hear. It's the order called. We are not going to pass any order. We are short of.
So
You are Mr. S.C.
S.C. Das.
S.C. Das. Third, Mr. Asida, still an counsel. Also, Mr. K. Bush, still an PP appearing on behalf of State Respondent. As per dated on 9/9/2025, no steps have been taken to delete upon the respondent number 2. Respondent number 2, for which this could not be issued. In this context, Mr. Das submitted that as the orders were not uploaded, he was not in a position to say as to whether the notice was issued on the respondent number. However, he submitted that he will take steps in issuing notice to the respondent number. Petitioner will accordingly take steps within 2 or 3 days in issuing notice to the respondent. Please the matter after vacation it will be this.
After vacation.
After vacation, and then it will be
There is a date in.
when your next date is fixed.
Yeah, 13th of October.
Next date.
Yes. So.
Then obviously it will be after 13th of October. It will
30,
be
30, 30th of October. 30, 30th of October.
Oh, 30.
Yes.
Then obviously it will be prior to that. You just make a mention before 30th.
If my lord pleases, a date may be fixed. It's as per convenience of this court. Before 30th of it.
Seventeen 10.
Well. Publish.
Lordship, here I have taken a step on 18/12/2024 upon the respondent number 2.
18/12.
Yes, Lordship. The notice was issued by this honorable court. I had order dated 13/12/2024. And I have taken a step on 18/12. I could not able to check the file because it was instructed me it was not permitted to check the file. The office note I could not go.
Office note is simple. Yes. It's a 10/9/2025. It says that neither the AD card nor any answer notice in respect of the respondent number 2 has been received back by this section.
Yes.
And it is still awaited. When you have taken steps?
18/12/2024. It is a matter of
24.
2024. So also this time my humble submission, it can be served for jurisdictional police
It can
station.
be done.
Yes. That
State is the respondent number 1.
yes.
Part Mr. K. Jed Ahmed, Lieutenant Counsel. Also part Mr. K. Bush, Lieutenant as per office note, dated 10/9/2024. The service is still awaited for the respondent number 2. Respondent number 2. In that context, Mr. Ahmed submitted that he took steps on the respondent number 2 on 24/12/2020. Accordingly, pray that notice may be allowed to issue through jurisdictional police station. Expert considering the submission made by an counsel. Let the press notice be issued to the respondent number 2 through jurisdictional police station. Steps will be taken within 2 or 3 days. 3 days. This is matter accordingly. After vacation.
What we date maybe because it is a matter of 2024 and this time it will be served for police station.
17/10.
Yes, sir. Lordship, I should provide a copy to the office of the PP. And then
No,
they
no.
will.
No, it is a POXO case, no?
Not a POXO case.
Then Lordship, then I need to submit a copy to the officer in charge.
And what procedure?
Through registry, my lord, it will
Yes,
it
through
will go.
registry.
ma'am. Through registry, he will take steps, my lord.
Through registry যাব না হয়
Through registry.
jurisdictional police station. Through registry it will go.
Through registry, man. He will
You
take
serve
the
a copy
steps
to
before
the
the registry, man.
That is through jurisdictional police station, concerned police station. It will be through registry it will go.
May I please also, in the questioning matter.
We have not received the LCR here.
Record 9. The record
No.
is not here as per.
I don't know why we have not received it.
Record will be required.
We need the, whether it was called for earlier.
Earlier, it's
Because service report was awaited.
actually the matter is also some forest goods were seized, so that was forest also involved, but they are not made a party because it's a police case, mine actually. Involved.
Yes.
Police case, mine. Forest is not the company.
Forest is also involved.
But my forest goods are involved, but provisions of the Assam Forest Regulation Act is also applicable in this case. But why police has not this included these
Narayan
provisions? I
Sharma
don't know.
Respond number 2.
My lord,
One Narayan Sharma is respond number 2.
he is the informant, police personnel, my lord.
Whatever you have
Head
made
person.
party,
Yes, he's been made party because he's an informant.
then service is still awaited for that person.
My lord,
It's still awaited, I think, for respond number 2. Have you taken steps? That's what I'm asking.
but they are my lord actually this
By name.
by name is there
By name.
Depend on it,
One additional affidavit was also filed by you.
But that is submitted by because even the forest department, he actually his petitioner was a deputy ranger at the time of occurrence matter, and he was absolved by the department also that no, there is nothing, no offense.
You are going to represent this one.
So,
But by name it
By
was
name
there.
it is,
That is the main difficulty.
Lordship.
but in
Otherwise,
official
he is a
capacity,
police officer that can be admitted, but by name it was there. However,
this
one
was issued by him.
office is there
That's also taken by him.
that with some illegible signature was there. That I don't know whether it was served or not. Anyway, it was listed for hearing, na. But basic thing is that we need the record.
A record will be required.
Even if we forget about the respond number 2. But record is not here. Inadvertently, it was not called for, or that I don't know.
Record corruption.
But no, it is not there. Record লাগিব না?
Record will be immediately.
Scan copy, yes, ma'am. Scan copy can be called.
Why you need here scan copy is required?
Scan copy will require records be or call my lord.
There is no such stay, I think.
No.
C is not open.
There is
You are mistaken.
in the meantime, case of Safid also, but still
I
they can
am
look into it.
University.
We are like pending about it.
Mr. Bush. Again, that begin as the taking up the matter, it is seen that not called for, which is required for hearing. According to the registries, you have a direct call for the scan copy of the case record of case record. Scan copy of the TCR. Where it is pending before?
Right. Huzai, man.
JMFC Huzai?
Yes, ma'am.
JMFC Huzai?
Yes, ma'am. Sankotem number Huzai, ma'am.
JFC Huzai Sankotem. This is the matter report after vacation. So this is the matter immediately after receipt of the TCR. After vacation, as an duty.
Also, that PRC number may also be noted, ma'am.
Yes, what is the PRC number?
PRC number 1344/23. The in the meantime cases is already charged sheeted of it.
Okay, we are calling for the record. Raise the
Any date can be.
No, this LCR will be
Yes,
received.
yeah, it is.
May I please, Your Lordship? This is a case of conviction under section 10 of POCSO Act, Lordship.
মানে